substitution of parties. This is a rule that helps you when there is a need to change the name of one of the parties. Well, when would you need that? Let's use an example. Let's say that it is a car accident case where there was a devastating car wreck at 60 miles an hour, and the defendant hit the plaintiff in his truck at 60 miles an hour. And the person who was driving and got injured was in a small car. And so their car was destroyed. And they were severely hurt. And they're in critical condition. And you file a suit in the name of, let's say his name is John Smith. So John Smith is suing Jim Trucker. And John Smith, who's injured, is now in a coma or is in critical condition. I would sue in the name of John Smith, or if I called him John Accident, and I would sue Mr. Trucker as him being named as the defendant. Now, all of a sudden, in the middle of the case, what happens? The plaintiff dies. The guy who was hit by the car dies. Well, now, he's not really the proper plaintiff. The proper plaintiff is the estate of John Smith or John injured. So I need to notify the court and the parties by either filing a suggestion of death or a notice of some certificate, death certificate or other document that proves it, along or attached to a request for a substitution of parties, to substitute in the estate of John injured for the plaintiff John injured. You actually file it by filing a piece of paper and a request or a motion to substitute parties, and then you explain in your motion why that is appropriate and proper. You generally can't use this type of rule to substitute in a party that you made a mistake on. That's more for non-joinder or misjoinder, a different set of rules. You use substitution generally when you have a good faith basis for putting that party in. And it is because of a circumstance that created the need to change that party.